In deciding whether or not to grant bail, the basic factor or denominator is to secure the attendance of the accused person to answer the charges brought against him. The court has to take into consideration various factors and circumstances, and one paramount consideration is whether the release of the individual will endanger public security, safety, and the overall interest of the wider public. We have what is called the Bail and Bond Guidelines 2015, which prescribe the following issues to be considered in grant of bail or bond. A, the nature of the charge or offense and the seriousness of the punishment to be meted if the accused person is found guilty, the strength of the prosecution's case, the character and antecedents of the accused person. Some of these are not relevant because this is a pre-trial detention before charge. The failure of the accused person to observe bail or bond terms, likelihood of interfering with witnesses, F, the need to protect the victim or victims of the crime, G, the relationship between the accused person and potential witnesses, H, child offenders, I, the accused person whether the accused person is a flight risk, and J, whether the accused person is gainfully employed. Sometimes we consider that, public order, peace or security, and lastly, protection of the accused person. All these considerations are meant to answer the determination of the constitutional threshold. Is there any compelling reason not to grant bond? With the advent of the new constitution, there was a bit of confusion respecting Article 49(1)H. Justice Ibrahim, then serving in Mombasa High Court, held as follows. However, the law changed with the promulgation of the new Constitution of Kenya on 27th August 2010. Under the provisions of Article 49, it is now possible for an accused on a murder charge to apply for and be released on bail or bond. This is the famous case of Republic versus Danson Mgunya and another, reported in the law reports, 2010 version, electronic version. In Ahmed Mohammed Omar and 6 others, Ochieng J, as he then was, relied on the following quotation from the above case of Faris CJ in Rex versus Hawken, 1944. The question of bail is sometimes misunderstood. When a man is accused, he is nevertheless still presumed to be innocent, and the object of keeping him in custody prior to trial is not on the theory that he is guilty, but on the necessity of having him available for trial. It is proper that bail should be granted when the judge is satisfied that the bail will ensure the accused appearing at his trial. My take is that bail is a constitutional guarantee for any person charged with any offense or arrested for any offense. The foundation of any criminal trial where an arrested or an accused person has been presented to court, and in particular where charges have been read and the accused has pleaded not guilty, is that he is presumed innocent until otherwise proven. This presumption of innocence cannot be ousted, and the denial of bail or the grant of prohibitive bail or bond terms may be a negation of this presumption. The grant of bail should be an automatic process unless an objection has been made for which the accused person would be required to respond why such an order to admit the accused person to bail or bond should not be made. These objections, in my experience, would take the form of evidence-based information demonstrating compelling reasons as required in the Constitution. Although the Constitution did not define compelling reasons, the contours of this definition of compelling reasons are becoming more clearer, and in case law have been held to include the following. 1, that the accused person is a flight risk and would likely not attend court whenever so required. 2, that the accused person is likely to interfere with witnesses. 3, that the accused person is likely to interfere with investigations by tampering with evidence or compromising the integrity of evidence. 4, in some instances, it has been argued that it is in the accused person's best interest not to grant. There are also others who include a 5th, that it is in the public interest. In brief, the prosecution's application is founded on 3 main grounds. 1, that the investigations have not been concluded, and if released, the respondents are likely to interfere with investigations. 2, that the respondents have demonstrated that they are likely to interfere with witnesses as they have made overtures to some and asked them not to snitch and possibly divert responsibility to some other innocent parties. I meant here to add to some potential witnesses. That there is enormous, number 3, that there is enormous public outrage and which is directed at the respondents and which may pose imminent threat to their safety and security. I will tackle the issues of interference together. On interference with investigations and witnesses, the court in Republic versus Dwight Sagarai and 4 others reported in the 2013 electronic versions of the Kenya Law Report on an allegation that the accused persons were likely to interfere with witnesses. The court held, for the prosecution to succeed in persuading the court on this criteria of interference, it must place material before the court which demonstrate actual or perceived interference. It must show the court, for example, the existence of a threat or threats to witnesses, direct or indirect incriminating communication between the accused and witnesses, perhaps even close familial relationship between the accused person and witnesses, among others. In the case of Republic versus Joktan Mayende, which was cited by Mr. Bwajo, 2012 electronic versions of the Kenya Law Report, my Lord Justice Gikonyo elucidated the instances where interference with witnesses would constitute a compelling reason, and how courts would adopt measures to curtail the grant of bail founded on this ground. These are the guiding principles that ought to be followed whenever faces to prove that the accused did acts tending or intended to interfere with a witness. The court is then entitled, if not bound, to infer the intention of the accused is in accosting the witness had been to dissuade the witness from giving evidence. Threats or improper approaches to witnesses, although not visibly manifest, as long as they are aimed at influencing or compromising or even terrifying a witness, either not to give evidence or to give skewed evidence, amount to interference with witnesses and an impediment or the perversion of the course of justice. He further added in the same case that all that the law requires is that there is interference in the sense of influencing or compromising or inducing or terrifying or doing such other acts to a witness with the aim that that witness will not give evidence or will give particular evidence or in a particular manner. Interference with witnesses covers a wide range. It can be immediately on commission of the offense, during investigations, at the inception of the criminal charge, in court or during the trial, and can be committed by any person including the accused, witnesses or other persons. The descriptors of the kind of acts which amount to interference with witnesses are varied. I think I want to emphasize here that interference with witnesses covers a wide range. It can be immediately on commission of the offense, during investigations, at inception of the criminal charge in court or during the trial, and can be committed by any person, including the accused, witnesses, or other persons. The descriptors of the kind of acts which amount to interference with witnesses are varied and numerous, but it is the court which decides in the circumstances of each case if the interference is aimed at impeding or perverting the course of justice, and if it is so found, it is justifiable reason to limit the right to liberty of the accused. In all civilized systems of court, interference with witnesses is a highly potent ground on which the accused may be refused bail. It is a reasonable and justifiable limitation of right to liberty in law in an open and democratic society as a way of safeguarding administration of justice. Undoubtedly, a cardinal tenet in criminal justice, social justice, and the rule of law in general as envisioned by the people of Kenya in the preamble of the Constitution of Kenya 2010. End of quotes. In the case of Republic versus David Ochieng Ajwang alias Daudi and 11 others, my Lady Sitati, now retired, pronounced herself on this issue as follows. In my view, the above fears are not mere whims on the part of the prosecution. I am persuaded that because of the volatility of the situation on the ground, the temptation to jump bail is heightened to such an extent that this court cannot overlook it. It is not in dispute that all the accused persons hail from the same locality as the potential witnesses. And this being the case, the danger of such witnesses being driven into a corner by the presence of the accused person so soon after the ghastly death of the deceased person is a real possibility. In addition, the fact that the accused persons are so many is likely to send a cold shiver down the spines of such witnesses and corner them into resigning not to appear in court during the hearing of the case, even if the accused persons turn up. In a nutshell, there will be no witnesses to testify. As Makandia J, as he then was, said in the case of Kiteme Mangi, Murder is a serious offense and attracts the death penalty. Self-preservation is a natural reaction or response of any human being. That self-preservation may take the form of ensuring critical evidence is suppressed forever or the applicant himself takes flight. Finally, such potential witnesses may not be comfortable seeing the accused walk around, knowing that their evidence is critical to the success of the prosecution's case. That is reason enough to cause such witnesses to have genuine fear, misapprehension, and anxiety. It may even lead to such witnesses refusing to testify due to genuine misapprehension of their safety. In the famous Willie Kimani case, this is the Republic versus Frederick Leliman and 4 others, the accused persons were denied bond. The court observed the role of undermining the criminal justice system as a key ingredient and component. Justice Lesit, now Judge of Appeal, had this to say: undermining the criminal justice system includes instances where there is a likelihood that witnesses may be interfered with or intimidated. The likelihood that accused may interfere with the evidence or may endanger an individual or individuals or the public at large. Likelihood the accused may commit other offenses. In this instance, where such interferences may occur, the court has to determine whether the integrity of the criminal process and the evidence may be preserved by attaching stringent terms to the bond or bail terms, or whether they may not be guaranteed, in which case the court may find that it is necessary to subject the accused person to pre-trial detention. She also observed further, in this case, the drama was when the matter was presented before Kimaru J, and the fact at the very start of investigations into this case, it was clear to the judge the risks potential witnesses in this case faced, behooving upon the judge to give certain directions in their regard, are all very telling, given the facts presented before this court when considered amongst the most heinous offenses for anyone to face. They are presumed innocent, as I have observed earlier. However, there are investigations ongoing that persuade the investigators that the nine are persons of concern to be charged for these offenses. The team of investigators believe they have the threshold of proof to prefer the charges. The office mandated with prosecution is in support of the application to detain them. There is a deposition on oath of that intention. Justice Lesit in the Willie Kimani case had observed further, it has been shown through various dispositions filed in opposition to bail that the potential witnesses in this case come from the same area as the applicants. It is not disputed by the defense that the accused persons hail from the same locality as the potential witnesses, and this being the case, the danger of such witnesses being driven into a corner by the presence of the accused person so soon after the ghastly death of the deceased person is a real possibility. She made her finding thus: in this case, I have come to the conclusion that there exist strong compelling reasons by the applicants why the applicant should not be released on bond. Stringent bond terms cannot guarantee safeguards to the integrity of the trial process. Neither can it guarantee the progress of this case to finality. In our case, the potential key witnesses are themselves minors and fellow students like the respondents. They know each other well. It is therefore not far-fetched that the respondents are able to reach them. It is a matter that has found its way in deposition. The deponent was not called for cross-examination, even though that window was available. I am persuaded that there is likelihood of interference, and this, in my view, is a compelling reason. But by far the most compelling reason remains the safety and security of the respondents. There are charred remains of victims still in the morgue awaiting identification after forensic matching. Parents sent their daughters to school and left them in the assured safety of the care of the school. They received the call in the still of the night that there has been an incident in school. Some were lucky to have received their daughters in good health, maybe traumatized, but in one piece. Others were informed that their daughters were injured and were hospitalized, nursing severe burn wounds. For others, there was no child, just information that they did not make it. Then information comes through that the fire was not accidental. Rather, it was an act of arson, and by known persons identified by their colleagues. One can only expect their outpouring rage. It is not far-fetched that some have thought of revenge. It is the reason we have taken every measure as a court to ensure we conceal and protect the identity of the respondents. They may well be innocent. That is for the trial court. Their safety is, for this court, of paramount importance. This is This is the position that the court cannot walk away from. In my considered view, this meets the threshold for measure of last resort as dictated by Article 53, Subarticle 1F. The introductory paragraph of the Judiciary's Child Justice Strategy 2017 reads, the judiciary plays a major role in protecting the rights and liberties of all by guaranteeing them justice. Our Kenyan national anthem depicts this perfectly by emphasizing the importance. It is safe to say that this arm of government is the guardian of the gates of justice in society. Justice is especially meaningful and valuable to children, who are one of the most vulnerable people in a society. They are the promised future because the state of the children now will inevitably be the state of the adults in the future. When we preserve the innocence and protect children, we consequently preserve and protect the future generation. A justice system that ensures children are treated in a specific manner, there are tenets of fair trial are observed, and there is no deprivation of liberty. And if it's done, it is as a measure of last resort. So every child is a unique and valuable human being. This is contained in that report, and as such, his or her individual dignity, special needs, interests, and privacy should be respected and protected. This also includes the victims in this particular incident. This was not an easy application. So this cannot be an easy application for any judicial officer. There has to be a balance between compelling rights of the children involved here. I am persuaded that the respondents ought to be detained as prayed. I have considered the period sought. I find that the 30 days sought can be shortened. The investigators can move with speed and shorten these days, so I will allow the investigators a period of 21 days to conclude investigations. I now allow the application. The 4 suspects will be detained at the Nakuru Children Remand Home, and of course I expect that there will be measures put in place to ensure that they are safe while there. For a period of 21 days from today, the matter will be mentioned on 24th of June 2026 for further orders of the court. And these are the orders of the court.
We are very much obliged, Your Honor. I don't know whether you mentioned 9 suspects or you said 4.
Did I say 4 somewhere?
I had 4 somewhere.
Oh, it is 9. Where am I? Did I mention 9 somewhere? 4 somewhere? Oh, yes. This is a problem of working without. So it's a 9, and they are respondents. I apologize for that, and thank you very much, Kipkoech, for that correction.
Is it possible, Your Honor, to come back on the 25th?
25th? Yes. Is that agreeable to all? That we push it to 25th? Although 24th is a Wednesday, it's our. Oh yes. There is a worrisome about that particular date. There are expressions of worry about that particular date. 25th June has some semblance of. Let's retain the 24th, isn't it? Let's retain also because this court sits on criminal cases on Tuesdays and Wednesdays, and 24th is unless we push it back to 23rd, which will now reduce the period 20 days from today.
We can have the 24th.
Let's have the 24th. Thank you very much.
Since it's a mention, Your Honor.
Yes.
We have the option of virtual appearance.
It's okay. We can always create that. Yes, but they will be brought in person. The respondents will be brought in person. I think it may be in your best interest to appear in person. And with that said, I think we are concluded. This ruling will be uploaded on the CTS once I'm done with corrections, removing the 4 and replacing it with 9 and other other issues. Thank you very much. I think now I want to clear the court. I have not. There are a few people waiting for me to finish up with my other diary work.